tailoring oh, also, even if you have a specific general list of documents that you want to subpoena, help your lawyer by tailoring it specific to that industry. You know, for dental practices, how many patient records do you have? You know, for a dental, and there are books out there, practice by practice. What's the name of the guy that used to come here that had a nice book on professional practices or medical practices? I'm sorry? Yeah, Mark Dietrich. I just couldn't hear you. Yeah, Mark Dietrich's got some good books out there. I'm sure somewhere in there is a subpoena exhibit. And you may, you know, ask Harold if you should have that in your library. Dry white toast. It ain't exciting. I've read his writing. It's not exciting. At least I try to throw in a little bit of Star Trek references. How am I doing? All right. Yeah, in my book, I tried to make a bunch of obscure Star Trek Next Generation references. It didn't always... and I knew somebody's brain damaged when I get an email. I thought what you said was funny. Now, so I called subpoenas are like duct tape. Subpoenas are a great way to bolster your discovery. And I likened it to bacon. I have a friend of mine that owns a restaurant in Memphis, and he says, everything goes along better with bacon. And I think subpoenas are that way. Yeah. It's like the bacon of the restaurant industry. Subpoenas are great because you can always brow people up or beat them up on what they didn't produce pursuant to the subpoena. So when I start a deposition of Mike, my first thing, we're going to go through the list of documents on the subpoena duces tecum, see if you brought them. And my favorite is, we've only talked about that 100 times here, but at the deposition, oh, it's in my car. Okay, well, we'll take a 10-minute break for you to go get those. Why didn't you bring them in? Subpoena's not a request, it's a court order. Is there some reason why you don't want to comply with the subpoena? Well, Mason, it's because you're an asshole. Like, okay, let's make sure we get that on the record. Because the judge is going to think, well, yeah, I know Mason's an asshole. I've known him a long time. All right. Yeah, I give you a whole bunch of tips on how to help with the rules. But yeah, the level of confidence, and I cannot tell you how many times I get calls from all across the state after a case has been screwed up and mishandled, mostly because the discovery was screwed up. And they want me to second guess, what can I do to help fix it? And I said, well, what did you issue any subpoenas? Well, my lawyer drafted one, but didn't file it because they said we wouldn't have enough time to get it before trial. Think about that. You got a business ownership situation in a divorce, and they didn't issue a subpoena because they didn't have enough time. Well, issue it with, your first set of interrogatories, requests for production of documents, and if the lawyer doesn't know to do it, beat them in the head until their head and cranium bleeds. We need to issue a subpoena. Well, they might give it to us anyway.
Why are they so resistant, though?
Because it's hard. It's hard. Yeah, the subpoena compliance motion is hard to explain.
Hard on timeline, hard on them because it's
both. And they haven't
judge to approve it. They got to argue it. What is the deal?
The question is, what's the deal? The question is, everything that I told you on Tennessee Rule of Civil Procedure 45 requires them to read it, issue it, and have experience dealing with this. And if they haven't done it before, lawyers don't want to do it. The motion, even in my office, I had one, and I think I don't know if Mike's helping me with this one, but I have one, we're filing a motion to compel subpoena compliance against Methodist hospitals for income records for a doctor. And Methodist Hospital won't give it to us. They're just being jerks about it, and I'm going to try to get fees out of it. But I've got to go write a motion for compliance. I've got to explain Rule 45 to the judge. I've got to do a fee application. So I've got to draft an affidavit of attorney's fees. I'm going to ask for a bifurcation so I can get my documents first, then ask for fees. And it's all pursuant to Tennessee Rule of Civil Procedure 45. And that's why the title of here is, what do A-list attorneys know that others don't? It's hard. But our job is to do what's hard. Our job is to be competent for our clients, even when it's hard. And just because it's hard, I mean, I'm telling you, it's that simple. They don't know who to serve because they don't know to look up on Secretary of State. All right, and if there is no Secretary of State, there's no separate legal entity. If there's no separate legal entity, have the process server show up to the physical location and drop it in the hands of a manager. Not that complicated. And then have your process server write down who they served, follow up with a request to confirm that they have it, and if they say no, then file a motion at the court that says, I've got this subpoena here, I've already served them. The husband owns the business, compel him to accept service on behalf of the business he owns through his lawyer. And his lawyer will show up and say, I don't represent the business, I represent him. Well, then you make the business a third-party defendant. Okay? But it's hard. But it's hard the first time. In the immortal words of Miyamoto Musashi, and I'll leave you with this. Hopefully everyone knows who Miyamoto Musashi is. The world's greatest samurai, author of the Book of Five Rings. Everything seems difficult at first because everything's difficult at first. And if you haven't been doing subpoenas regularly, it's hard. And we do training on subpoenas at my office every 6 months. All right? Any questions? Hearing none, we're back on time. Yes? Yes, Chef? Thank you very much for your time and attention.